Yep, it's so good.
Good evening, ladies and gents. Cyril here. Welcome to the last session of 2017. This is our 6th week. Now, I'll just go through a few housekeeping matters and then we'll go through the week's details. Don't forget that on the 5th of January, you'll have to have your 40% assessment in. Now, I hope by now you've all downloaded it. Now, I had one, I put it out about a week ago, and then I saw there was a minor error in it. So download the more recent one, the one I put in, which I put up yesterday. Okay, so just have a look at that. Now the thing is that it's Christmas next week, so don't turn up next week. The week after we'll be back again. This week we're in certainty and completeness. And just want to say to you, in your notes, in your study guide on page 16, you go through what we've been doing so far. So far we've been looking at capacity, you know what that means, does the person have the capacity? Second one, legal relations, which is basically your intention to be legally bound. The third one is your offer and acceptance, which some books call it agreement, because indeed it is an agreement if there's an offer which has been accepted. Next one is consideration. Then the next one really is 5 and 6, which is tonight. That is your certainty and completeness, and then do you have the correct form? So you need to answer yes to each of those. Okay. Now, depending on which textbook you go to, they're all slightly different, but ultimately all basically the same. Okay. So it's like different ingredients. Whilst I'm not a chef, if we're making a scrambled eggs, if you put one ingredient before the other one, so I hope it doesn't make any difference. But same thing here. You swap the ingredients around a bit, but basically that's what. So let's start. So as in previous weeks, I'm just going to paraphrase what's in our study guide, have a bit of chat with you, answer any questions, and then we go to our weekly question. Right? So on page 1, we've got just a bit of discussion as we usually do. Page 2, we have our cases. We got 10 cases there. Again, it's helpful if you know how to each of them. When I was in law school, I remember the professor said, if you can't summarize a case into a paragraph, you haven't got the gist of it. So what I've done here on page 2, I've just made a little annotation of 2 lines on each, just the key issues there. So you should be able to do that. Next one is key terms and concepts. You should read those and have a good feel of them. Now tonight we've got a lot on certainty and completeness. And I think it's actually pretty important to understand what each of them are. Particularly, we have our tutorial question later on. So certainty is a contractual provision which is sufficiently certain if it can be understood on its own terms or by reference to some known outside factor. If a contractual provision is uncertain, then it may not be able to be enforced. So it's got to be sufficiently certain. Now, when we do our question number 9, our problem number 9, it's either going to be uncertain or incomplete, or could be, but the issues of certainty and completeness will certainly be discussed tonight. The second one is completeness. That's a contract lacks completeness if some essential or important term is not included in the contract. The court will usually go to some effort to fill the gaps, but if that's not possible, then the contract may not be enforceable. Okay? So if you can, try to make them complete or have some sort of mechanism which can help. Okay? And stop me wherever you want. All right. On page 4, under the heading of certainty completeness. Now, we just had a bit of a general background, and I'll just quickly go through that, and you'll see at the top, we know that the parties got to get together, have the consensus at item, and there must be a one mind, complete agreement. And so top of the next paragraph, it makes sense, therefore, the contracts must be sufficiently certain, okay? Because person A is thinking about the agreement, person B thinks about it, hopefully their minds meet, and therefore, as it says on the top of the second paragraph, it makes sense, therefore, that contracts must be sufficiently certain. All right, so let's have a chat about the case of Scammell and Nephew and Alston. Can someone give me just the brief facts of Scammell's case?
It was basically he was buying a truck or a lorry, as it states there.
Yeah.
And it was on hire purchase, but they hadn't organised who the hire purchase was. And before they'd done that, he pulled out of the deal. They used him pull out of the deal.
Okay, so the buyer pulled out, the vendor wanted to enforce it, and after a number of court cases, what did the House of Lords say?
They said it was obscure, that they couldn't work out what the end result was supposed to be with the hire company, due to the fact that there was no details as to who it was.
And we all know the House of Lords is almost at the top of the tree. Maybe with Brexit it'll be at the top of the tree again. And so it was too vague. And then we had the House of Lords, we had Lord Wright giving his judgment, and part of it, I don't want to read the whole lot, but the indented part is really important there. And you'll see the first sentence there. The language used was so obscure and so incapable of any definite or precise meaning, the court is unable to attribute to the parties any particular contractual intention. See, the job of the court is to enforce contracts. It wants to enforce contracts. And as we see later on, and as you've read, if you've actually started executing the contract, in other words, in plain English, if you started doing it, well, the courts see you've actually started, and it wants to help out. And also, as you've read in the notes, it's a little bit unfair if you don't enforce a contract. One party's done what they're supposed to, and the other party can get out of it. In the second paragraph, the second sentence, the object of the court is to do justice between the parties, and the court will do its best if satisfied that there was an ascertainable and determinate intention to contract to give to that intention, looking at the substance, not the form. So it wants to go ahead. And the last sentence in that indented paragraph, if these words considered, however broadly and untechnically and with due regard to all the just implications, fail to evince any definite meaning on which the court can safely act, the court has no choice but to say there is no contract. Such a position is not often found, but I think that it is found in this case. Now, go back to what I said. It is the job of the courts in contract law to enforce a contract, if it can, because the parties have got together. They wanted to get together. Usually there's an argument about one term. One person thinks it's X, one person thinks it's Y. The courts will try to enforce it. And as I repeat myself, particularly if someone has already started. So you see there, if they can't get any sense out of it, they'll regrettably say there is no contract. Okay, and they go at the bottom of the page, they go for the separate requirements, they talk about a couple of things there. But let's keep it simple. And on the next page, we've got certainty, which is page 5, and they talk about the case of Biology Australia and PACE, 1988 New South Wales case. So someone give me the basic facts there.
That's the poor sod that put on a seniors equity shareholding.
Yeah.
The what?
Except
there was none.
There was none. Okay. And so what did the court find?
Well, I couldn't make a ruling on something like that if it didn't exist.
Yeah.
I couldn't work out what type of shares, how much they were paid for, how many. Yeah.
And that's a good point, because if it's simple and it's pretty straightforward, the courts may infer something, but there were too many issues here. The court, however, found that the promise for him to participate in the senior equity staff scheme was too vague and uncertain to be enforced. Okay? So they're the bits and pieces. Now, once again, if it's too vague, the courts will knock it out. Now, the courts want to save the contract and honour the intention of the parties. And so there are 4 key ways, and you'll see them on page 6 and onwards. The first way is with executed contracts. Second one is with reference to external standards. Third one is reference to reasonableness. And the final one, if you have to sever. And that's an interesting point with severance. I think it's the 11th week. What we'll be doing is we'll be looking at the Australian consumer law, and they have a number of provisions there, but one is in relation to unfair contracts. And I may have mentioned this to you a couple of weeks ago, but it originally started off about 7 or 8 years ago when the Australian consumer law first came out. So you'll have gymnasium memberships, you'll have airline tickets, and you'll have telco contracts and things like that. Now, what happens is the consumer, you have a smaller consumer like that and a very large vendor like that, which is usually the case. And they push very onerous terms onto the consumer. And this is now being expanded to small business. So it's actually quite relevant to you people if you're involved in business. And what the result is under the new under the unfair contract terms, that's for consumers and for small business, the courts can pluck out a clause, and that's exactly what they're doing here. So that's under legislation doing it here, but under common law, you can pluck out a clause, and that's what they're talking about here. But you can't pluck it out if it's going to destabilize things. I'll give you a medical example. If I have a bit of a cancer here in my rib cage, they cut it out, bang, I'm right. But if, and I can still stand, I can still function. But if it's in the leg, you have to cut the leg off. I can't stand anymore, I can't function anymore. So that's a sort of a vague analogy to it. So we'll leave that to the 11th week. So let's have a look at 3.1 on page 6, saving uncertain but executed contracts. So basically the summary there is in the second paragraph. The reason for this seems quite clear. As soon as one party has begun to deliver on their obligations, they are placed in a vulnerable position and are likely to face losses if the court voids the contract and allows the other party to escape their obligations. Okay, so it's really important that the so when you start doing something, it also shows intention. So if we haven't started doing anything yet, well, that's one thing. But if I've started doing something, or you've started doing something, and here they were talking about the next paragraph. Can you imagine if the truck vendor in Scammell and Alston went ahead and provided the truck, and then the whole thing didn't work out? Let me just close the door. With Scammell and Alston, if they provided a truck and they got it back second-hand used, it's not fair. It's not justice. Right? So that's the first key way the court can save the contract. If something's been executed. Okay? The second way is saving uncertain contracts by reference to external standards. Okay. Now, another example, we'll do Hillis and Arcos in a second, but another example would be if Daryl and I, we decided to work out a contract in relation to oil or whatever it is, and we decide upon the Brent price. We pay the Brent price on the Singapore exchange, let's say at 31st of December 2017. In my opinion, that's perfectly okay because you're making a reference to an external standard. Problem is, what happens if you don't have an external standard like that? And we'll see that shortly when we come to a case later on about, it was the Fitzgerald and Masters case. But anyway, for the time being, Hillis and Arcos, who's going to have a go? Michael, going to have a go?
I'll do that one.
Yeah.
That's, Arcos was to purchase, well, a lot of standard of Russian softwood for a specification,
yep.
And they had an option for another 100,000. And when they went to do it, there was no price. It just said same conditions, less a discount. But again, there's no agreed price specifically. What's the discount? And so, yeah. So basically, how can you do it? And what timber would it be? So,
see, a lot of these cases, there's a reason for people litigating, and it seems to me that the buyer, they went into a purchase contract with an option to purchase later on. My recollection of the case is that the vendor said, look, exercising the option, you have to buy it. And for some reason, they don't want to buy it. They don't need it. The price has gone up or whatever. For whatever reason, it doesn't matter here. But the fact is they want to get out of it. and the court said, and then they had to think of an excuse. So they go to the lawyers, and lawyers will just give it a go, and they're being paid for it. And they'll just give it a go, and they'll say, look, we don't know what to say. Look, let's just give it a go and say that it was too vague, that it was uncertain. Okay? And the courts came back and said, well, it's not really uncertain. You did buy in the past type X. Well, just because we didn't put in the narration type X this time, it's pretty obvious it's in the past. Okay, so that's an external stamp, and the one I gave you in relation to the oil, which I made up. So having an external stamp, and these things can be expected because when you're dealing in the future, you may not know what price there'll be, or some type of an issue. And an example is our problem number 9, which we're going to be doing later on, which is an event which will happen in the future, which we don't know about at the moment, but we need to take some sort of we need to do something about it. Okay, so 3.3 on the next page was saving uncertain contracts by reference to reasonableness. Okay, so again, it's Scamble-Alston's case, and what would have been reasonable in the circumstances, the author here, Anthony Marinac, says that he's not too convinced by this approach because people are entitled to make their own agreements as to amounts. Now, Michael, you've got a boat, haven't you? And just say you're totally pissed off with the boat, and you know me, and you just say, look, you can have it for $100. Okay, yeah. I know you wouldn't, but you say you have it for $100. That to you and I is reasonable because there might be a relationship with friends, brothers, etc., etc. To the outsider, that's that's crazy, and that's what Anthony's trying to say is that there is a bit of an issue with this reasonableness thing here, but you'll see here they might be relating to some sort of terms and conditions here, and that they talk about it's reasonable to use those of the industry. So that's the case. And he also makes a note from memory that you've got to be careful if it's not. If it's not saved, or if there is no if there's no attempt to save it, it's going to be void. So just having an excuse of reasonableness is probably better than none. And the last one here is severing uncertain terms. And just under 3.4, it says, in many cases, the court will look at uncertain term and consider how the contract might appear if the term was simply ignored or severed from the contract. Okay, so that's important. We'll, as I said, we'll have that later on in the unfair contracts legislation, both for consumers and for small business. And the court will sever a clause as long as it doesn't destabilise the contract. Two issues here. First one, if the uncertain term is relatively minor, for instance, or if it governs a contingency which has never come to pass, then it can be no harm in removing it. On the other hand, this is the second part, if the term is an important one and changing it would substantially alter the nature of the contract, then the court is unlikely to save the contract by severing it. Okay, so let's take examples of those two. So the first one, example of severance, is the Fitzgerald and Masters case, and later on, again, we have not severed is the Scamble and Alston case. But would someone like to give me the facts of Fitzgerald and Masters?
Well, at Fitzgerald and Masters, that was in relation to a survey of a land deal.
Yeah.
And they made reference to a New South Wales Real Estate Act, or Crown Lands Act, it says on here.
Yeah.
But the Act didn't exist in relation to it.
You've got to be careful when you do these things. It's easy to laugh. You've got to check these things out. And good drafting would be, number one, check that it actually exists and check the actual name of it. So you're right. You don't want to have certain name and you use a different designation, number one. And number two, sometimes if you really want to play it safe, you say, or in the alternative. So if the Crown Lands Act, et cetera, doesn't exist, you'll have something else. But there's something really went wrong here. I don't know what happened. And you'll see that they want to find out what really happened and between the parties. In this case, it's the subjective test. You'll see the second bottom paragraph of page 7. They really want to see what the parties intended, because we're trying to save this contract. We're not talking about the mythical bystander. We're talking about the subjective test, what the people really intended to do. So Fitzgerald's and Masters is a case of where you could sever, because what had happened is that the court thought, well, this is what the parties intended, therefore what we'll do is we'll give it to them and just sever that part out of it, because it doesn't really make that much difference, because they wanted to be bound anyway. So just because that act doesn't apply, it doesn't exist, we can do without it. However, where it wasn't severed was in Scamble and Alston's case, where it had to be on higher purchase terms because they didn't have the cash. So it had to be. And so that could not be severed. And in that case, you might knock it out. Okay? So it's just an example of it there. Then we had incompleteness. And the whole idea here is that it's going to be as complete as possible. Otherwise, it won't be enforced. So let's say the whole thing. You will have situations, frequent situations, where you just can't think of everything, and so generally speaking, the courts will enforce the contract. However, not in the cases where it's an agreement to agree or where there's a discretion, which is called an illusory promise. Okay, and incompleteness is where we don't have enough detail in the contract and we really can't understand the obligations of the parties. Okay? So if we go to page 8 at the bottom there, our starting position on the issue of completeness must be this: no contract is ever entirely complete, even if very simple contracts does not cover all the possible contingencies, nor does the details of the contract, etc., etc. Next paragraph. As a result, if it was possible to avoid a contract simply because it was incomplete, no contract would ever be enforceable. Okay, because you can't get everything in the contract. On the other hand, sometimes the omission of a term might make a contract completely unfathomable. And they were talking about Scamble and Alston's case again. Well, what happens if we don't know the price? What happens if we don't know the type of truck? I mean, they're fundamental things, and you really got to have those right. Okay. Such omissions would go to the very heart of the contract, and it seems impossible for the court to enforce such a contract. The court will assume that the parties intended at some future time to fill in the blanks, but that does not mean the parties have yet got consensus at even. Is there a contract at all? Okay, so yes, we do want to go into the contract in the future. Yeah, I'll think about the price, or I'll think about what sort of truck. It doesn't show there's been a meeting of the minds. There may have been, we're getting close to it, but it doesn't show a meeting of the minds at the moment. Next page, page 9. So, and we talk about Booker Industries. Now, they don't give us any real facts about Booker Industries. Did anyone look that case up? There's a chocolate if you did.
Yeah, I looked it up on in the contract law book. There's the case book and the law book. The case book has like 5 pages. This is on page 102. The parties entered into a lease agreement under which the lease was given an option to take a further term. The rental for that further term was to be agreed with the leaseor, or failing agreement to be determined by an arbiter.
Yeah.
High Court held the option constituted a valid agreement in his judgment. So,
and why? Why was it valid?
He drew distinction between a clause in determining price or rent where the manner of calculation as set out in the clause was essential to the parties.
Yeah. So basically, the landlord said to the tenant, we're going to have this rent, and they either agree, if not, they go to the President of the Law Society of Queensland, and the tenant was trying to say it was uncertain, incomplete, and the High Court said, no, it's not incomplete. It's pretty obvious that there's a mechanism there. So and therefore it's enforceable. So that's good. So that's the Booker Industries. Now let's have a look at agreements to agree. So can someone give me the rule in relation to agreements to agree? What is an agreement to agree?
It's an agreement that you're going to agree on something there sometime in the future when you go and agree to it.
Exactly. So is there a contract?
No, it says it's unenforceable.
Yeah, and why? Why do you think that's the case?
Probably too vague, too far in the future. You're not too sure what you're agreeing to, and you agree to agree to agree.
You're selling your house, your car, your boat, whatever, and you're saying, you want $1 million, and I want to pay 900, and we'll just you're thinking of coming down a bit, I'm thinking of going up a bit, and look, let's do the deal now, but we'll agree upon the price in the future. Well, I don't think that's enforceable, because it's a major term. And so if you were a judge, would you enforce that? What do you enforce? Well, what's the price? Because the price is a major part of the consideration, So you've got to get that right. And so here it says, how should the courts treat a contract which contains an agreement to agree? For instance, what if in Scamble's case, the parties agreed to the purchase of a motor lorry, which is a truck, with the price to be agreed on the date of delivery? If you had a mechanism, another one would be Westpac term deposit for amounts between $1 and $100,000 on a certain date. You could do it, but even then you've got to be careful, because what happens if they change their type of accounts? Generally speaking, contracts which contain an agreement to agree will not be enforced. After all, it can hardly be argued that parties are sensus ad idem if they have not agreed on all the important elements of the contract. What happens if then the moment comes the parties are unable to agree upon the outstanding element? Well, they are. In some cases, when the outstanding agreement was related to the price, the courts have been prepared to imply the agreed price would be a reasonable market price. Now, they've got to be really careful with that. And then I give the case of Foley and Classic Coaches. Okay. So who would like to have a go? Sorry, Foley's case. What happened there?
There was an agreement to buy land for a service station.
Yeah.
The bus company agreeing that they'll buy their fuel from that service station only, and that they had an arbitrator. They'd get together from time to time, I think the term was, to go and work it all out as to how much the fuel's going to be.
And the contract had two key parts to it. It was the sale of the land. So I am the landlord, the property owner. I sell it to you, and you'll so we'll sell it to you, and therefore you'll pay me lots of money for that. But also you'll run on this petrol station, but you'll give me petrol for my buses at a certain price to be determined in the future. Because there was a dispute resolution mechanism, and it was a less important term of the contract, it was held to be we'll use a reasonable price. Okay, but you wouldn't want to rely on that sort of stuff, because look, that's where lawyers make their money, and you fight it out. I don't like that. My clients don't like it. I don't like it. Anyone should do it. You should always be in the driver's seat. And to be in the driver's seat, you need to draft your contracts as tightly as possible. Granted, as we saw here, you can't ever put the whole thing in, but you've got to think of the key points. And risk management is exceptionally important, because the contract allocates the risks. Who's going to take what? So, Daryl, if you want to do some work for me, you'll have to do this, this, and this. And if you go ahead and agree with that, well, then therefore you're responsible for those. And we've got to make sure they're clearly written into the contract. And as contracts get bigger, the stuff I deal with, 300 pages, unbelievable stuff. You wonder why there's not many more arguments. So that's agreements to agree. Now, just while we're there, can someone tell me about agreements to negotiate? Well, what's an agreement to negotiate? And is it binding?
No, it's not binding. It's just saying that we're going to sit down and talk and try and come to terms.
Yeah. That's dead right. And we had the Cliff Colliery's case. What happened there?
One party wouldn't really sit down and communicate and have a negotiation with them. So they failed in there. All they had to do was negotiate with them and then not agree.
Yeah, see, to the outsider looking at these cases, you have to ask, why they do these silly things, But we don't know the full story. But I can certainly say to you, if a contract says you must do X, Y, and Z, you're absolutely nuts if you don't do that. Mm-hmm. I remember a case where the either buyer or seller, I can't remember, did the wrong thing, and the CEO of the innocent organisation, the injured party, said, "Nah, we're not going to bother with a contract. We're going to go straight to litigation because they've completely screwed us up. They've done the wrong thing." But the court threw the book at the innocent party and said, "Look, you have a contract. It says if there's a dispute, you must follow this procedure," and they didn't do that. Okay, so the court doesn't look at the whether someone's done something wrong or not. It would look at the contract, and in that situation, the innocent party had to go back and follow those procedures through. And so we don't know the full story here, but simply speaking, if you have to do X, Y, and Z, just go ahead and do it. If it takes you an extra month to do it, follow it. If it says that you have to send a letter and it has to be express post and it has to be this, and this, you just do it. Doesn't mean that you can't do it otherwise as well. But follow to the letter what the contract says, because you don't want to be standing there in front of the judge and have to explain why you didn't follow the contract. So that's Foley. Sorry?
What would be the outcome on that Colliery one? They were just having the negotiate. So they haven't even done anything, haven't signed anything. All they're doing is trying to work everything out. So what would the judge actually say to them? You must sit down in that room until you work it out.
Yeah, well, so that's a funny thing. I haven't got the full case in front of me, but the judge would say, remember what the job of the judge is to enforce the contract. If the contract says, you two have agreed to negotiate. And what they do now, they go into a room and negotiate, and that's it. So the whole thing, when I read this, I thought, there's more to it. There's more to it than this. See, what happens is that a lot of cases have multiple issues. They might have a tax issue. So when you're studying tax, you'll be looking at the tax issue. They have a corporations issue. Then they have a contract issue. We don't know the full story here. So just passing on from there. So the next one, that was agreements to negotiate. So we had to look at that one there. So there's no reason why you can't negotiate, because a negotiate is a finite thing. It's you sit down and you do it. Whether you come up with a resolution or not, that's another thing altogether. Now, 4.3, reference to a mechanism or a third party. In a way, we've discussed that. You'll see in the first paragraph under 4.3 on page 11, sometimes a contract might be incomplete because it refers to events or circumstances in the future, and the parties have no realistic way of predicting them, or alternatively, they may need to retain some level of flexibility to respond, for instance, to market conditions. One way in which the parties can manage this situation without ending up with an incomplete agreement is to include reference to a mechanism or to refer to a decision, refer the decision to a third party. Okay, and you'll see that thing with the Hawthorn Football Club and Harding. All right, now. Harding was from Western Australia, so therefore I think, Michael, you're from the West. You better tell us about this case.
Yeah, I watched the bloke.
Huh?
I watched him play in the grand final. This fella, so for my beloved Eagles. So, well, he was a waffle player, and as back then you had to do X amount of years in your state before you could move to Victoria and play in the VFL, and so he was recruited, paid, and to develop his skills, I guess, and hit the age, because they couldn't poach him at 18, to go and play. And then he didn't want to go because a Perth team was brought into the league when it changed from VFL to AFL. And so he wanted to try and stay and make the contract void, which he failed to do.
He just loved the Subiaco ground that much. He didn't want to leave, did he? You know.
Why would you want to leave over here, eh?
And so, what did he allege, and what did the court respond to?
Okay, so I have to read back on this one. They ended up going to arbitrators initially. Hawthorne's.
He basically said it was too vague, and that makes an excuse up. And the court said, "Well, hang on, there's a mechanism. How can it be too vague? No, there's a mechanism there."
Yeah, had arbitrators.
Above the photograph on page 12, Hawthorne sued to enforce the contract. And the court determined that by establishing a mechanism to resolve any disputes between the parties, they had established a mechanism to repair any potential incompleteness. The contract was thus enforceable. Okay, so I go back to what I said at the beginning of the tutorial tonight. When I was in law school, the professor said to us, "Look, you should be able to summarize. So if you can't summarize a case into a paragraph, you haven't got the gist of it." And so a couple of lines, those 3 lines I read out, two and a half lines I read out, just be able to summarize very, very quickly as to basically who did what, and what did they allege, and what did the court hold. And of course, the higher the category of the court, like the High Court of Australia, it's gold, you know, if whatever they say. But then again, you know, if it goes back 70, 80 years ago, that might be a bit different from very recent cases. Yeah. So thanks, Michael. Daryl, tell us about 4.4, allowing one party discretion. What's all that about?
That was if the contracts are incomplete, you're allowing somebody to dictate some of the terms at some future time.
Yeah.
Maybe the price, it might be what the goods are, or I don't know, the condition maybe. But you're giving them the option of telling you what to do down the track, basically.
Yeah, and that becomes a discretion.
Mm.
And if it's discretion, there is no consideration. You've got to be very careful there. Just for sake of completeness, the first 2 paragraphs on under 4.4. What if the contract resolves any potential incompleteness by allowing one party or the other the discretion to determine the missing provisions? For example, in Scammell's case, the contract had said the purchaser was to be by hire purchase subject to such reasonable terms and conditions as may be arranged by the seller. In general, such provisions will be enforceable. The High Court has said in Godeke and Kerwin, there is no reason in principle for holding that there cannot be a binding contract if some matter is left to be determined one of the parties. Well, you or I, we actually agree to that. And remember, the court's not there to rewrite the contract. The court is there to enforce the contract, which has actually been agreed upon. But that's as long as it's not inconsistent with the contract from an objective viewpoint. And then we look at the illusory contracts, which is on the next page, illusory promises. We had on the 3rd paragraph down a contractual provision which leaves one party in a position where they can choose whether or not to deliver on their promises described as an illusory promise. Contracts containing an illusory promise are usually invalid. Okay, so one of you, would you like to have a go at Robertson Smith?
Oh, that's the fellow with the timber mill.
Yeah.
Poor sod. You should have used a solicitor.
I tell you what, in my office, I used to have a drawing, a painting of this barrister. He's got this bottle of something strong sitting on his table, and he toasts to the testator. In other words, the person who's written the will, who hasn't used a lawyer, because they usually screw it up, you know. And that's how lawyers make their money, you know. So don't feed the bastards, and just do the contract right the first time around. When I write a contract, I usually write for the sake of for the avoidance of doubt, you know. So just spell it out for the avoidance of doubt. If there's money involved, we do I'll do a calculation. There'll be formula. Then what I'll do, if Daryl, you're working with me, I'll say, Daryl, have a look at this, run a set of figures through it just to make sure it works fine. And I think having a reviewer is really, really important. I'll give you a funny story. I wrote a contract one night and I gave it to my wife to read. She's a commercial person, which is good. And she said, "Dummy," that's the way she speaks to me. She said, "Dummy, you've forgotten the price." Look, the more I looked at that bloody contract, the more I couldn't see that I'd missed it. And that's why a review was very, very helpful. Now, we're going beyond the scope of the course here because the scope is talking about the academic aspects, but I'm just talking about the practical aspects. Really, if you are doing a contract yourself and it's of significant importance to yourself, get it checked out. Right? It's important. Clearly, you've got to make sure that the parties, you've got the right parties, you've got the right price, and you've got the right, what's the other consideration on the other side. And as from tonight, we've got to make sure there's certainty, completeness, amongst all the other factors too. So that was Robertson Smith, but basically it was all too vague and too sloppy. You've got to be really clear with these things. But look, again, we weren't there at the time. We don't know the pressures on these people. And you and I have both been in situations where you said, someone asked us about it, and we said, look, you had to be there at the time. It was really difficult. To an outsider, it's hard to see, but you need to have those things. And in the last paragraph of the 5.1, second sentence, however, the court found that the contract was invalid because the requirement for Roberts to be paid was simply illusory. Sorry, did someone want to say something?
I'm going to say 1859 in England, they were getting shipped off to Australia and overpopulated, hard to get a job and getting hung.
They were sending them to Perth at the time.
Yeah, they were, yeah.
Okay, let's go to the next one. Now, paragraph 6 on page 14, formalities. What does that mean in plain English? Tell me about that. What do they mean by all that?
Oh, that's the formality of the contract itself. It must be in writing, signed. Not necessarily sealed and delivered, though, is it?
No, we'll talk about that. Look, under the common law, no contract ever has to be in writing.
Yeah.
Now, this led to an enormous amount of fraud where, Daryl, you've got a property and I say there was an oral contract for you to sell it to me. And then you couldn't appear in court because at that stage there was a prohibition of you being a witness. Perpetrated a lot of fraud. So in the late 1600s, the Parliament brought in the Statute of Frauds. And since then, we've had a number of different extensions of that. But mainly it's there to protect. And you'll see here on page 14, third line, provided that all other elements of the contract formation are met, an oral contract will be perfectly valid. Oral contracts do so to raise more difficult issues of evidence beside the point. If a party can prove the existence of the terms of the contract, an oral contract will be enforceable. In some cases, however, the law prescribes certain contracts must be in writing. These are generally either self-evidently or more important transactions, like the sale of a house. No, it's a bit wordy. What they mean is it's an important asset, or B, where there is a history of potential abuse. Now, so what we had through history now for 400 odd years, we got a situation of real estate, buying and selling real estate. To get an interest in land, there must be something, a note, a memorandum in writing. Now, there are ways around that because if someone has, as you probably read in the notes, someone has built on your land, and you just watch them build on your land, and then after it's finished, you get rid of them and you say that's mine now. That's a little bit stiff. So there are certain ways to overcome it. But just if you remember, whenever you deal with land, the first thing you're going to say, it must be in writing. Otherwise, it's unenforceable. And the second part is there are certain areas where there's potential abuse. So when someone knocks at the front door, these door-to-door salespeople, therefore it's got to be in writing. Also, guarantees. When you guarantee for someone, someone goes to get a $100,000 loan, a relative or someone else, and you guarantee that if they can't pay, you'll pay. That's got to be in writing. All those sort of things. So once again, until the late 1600s, every single contract could be verbal. Okay, if you wanted to put it in, fair enough, you go ahead. In fact, it's wise to do that. But since then, the statute of frauds has come in, and that's now got different names for different states. But basically, all land to be transferred needs to be in writing. Now, 6.2, consequences of non-compliance. What that means in plain English is that it's not enforceable. Okay, the contract's not enforceable, and it makes a lot of sense. Is that the law recognises that this is an area where there is potential abuse, particularly in large transactions like land. And if you haven't done what the law asks, too bad. You can't do it. Now, where are we?
6.2.
Consequences of compliance. We've done that. We've got a bit of a summary there on page 16. Just to remind you there, when you're doing a question, well, indeed, when you're in practice and you're creating a contract or determining was there a contract, I do a lot of corporate training for executives in contracts. And we have lots of funny examples of cases. And I just ask them, is there a contract or not? And again, on page 16, you see, did the person have the capacity? Usually business people do. Legal relations. What's the rule in relation to legal relations if it's a commercial contract?
It's intended to be bound.
Yeah. And you can overcome that, rebut that by having an honour clause. And you remember that we had that English-American case. I just forgot the name of it now. And then has there been an agreement which comprises of offer and acceptance, and ultimately offer and acceptance work together when there's a consensus ad idem. Needs to be consideration. Consideration, you must show quite clearly something goes in each direction, and if you can't, you're in deep trouble because you won't have a contract. And that's what we was talking about before, about having an illusory promise. Someone's not doing something, therefore there's no consideration. Now, your question, Daryl, before is what can you do in that situation? Well, simply what you do is that you have a deed. A deed overcomes lack of consideration. And the deed is you just get an ordinary contract out, and on top, instead of it, I'll just pull a contract out for you. Just wait for a second. I'll just pull it out and show you. If I can get my hands onto it quickly. I hope. Here's a contract, and you'll see at the top there, this agreement. Can everyone see that? This agreement?
Yeah.
And if it was a deed, it would have this deed. So they're basically the same. A deed is a state-by-state law, and it must be in writing. And it's got to follow the state law. But basically, they're all the same. And you write this deed, and in this case, it's an agreement. And then you go to the execution clause, and you'll see here, executed as an agreement. In that case, it'll be executed as a deed. Now, if it's my corporation, I would sign it under Section 127 of the Corporations Act. And if it's one of you two signing on the other half, it would be signed, sealed, and delivered. So individuals use the word signed, sealed, and delivered. And in the case of a corporation, you've got to follow Section 127 of the Corporations Act, which basically says that a single director, blah, blah, blah. It just gives you a prescription as how you do and you don't sign that. Okay. Now, so that was the consideration. We spoke about that. So the fifth item then is it sufficiently complete and certain and free from illusory obligations? Okay, so that's what we're doing tonight. Now, depending on which textbook you read, sometimes what they do is they put that in into the part 3 there, offer and acceptance. So the offer and acceptance must be complete and certain and free from illusory obligations, because it makes a lot of sense. because the agreement must be complete and certain. Okay, I was just doing a bit just about before we started tonight. I just pulled another textbook out, and they had that under the terms. So I couldn't find it anywhere. So I went and looked a couple of cases up, and there it was under the terms. So it all makes sense. The terms must be there. But I think it's better in the setup of a contract to determine, do we have a contract, yes or no? We've got to have those 6 things. You must answer yes. The way this other book had been written, it was a term which needs to be, a term is something later on which you consider down the track. But I like it here because if it's not complete or certain, you don't have a contract. Okay? So you need to set so those 6 things. Another textbook had it can't be illegal, can't be an illegal contract. Another textbook has something else about the parties had to consent to there's no misrepresentation and stuff like that. Doesn't matter. What you do, you follow the notes of your university here, and in part 2 of this this term, they'll go through that. So I just wanted to let you know that things differ. You're in front of a magistrate or judge, and you say, Your Honour, I want to go through the 6 different aspects of the creation of a contract. So, which university did you go to? In my case, it was 7. So it's all different. So just be aware of that, okay? So, and then you'll see under the 6th point, if you have answered yes to all these 6 questions, then the contract is in existence, okay? And there are certain things which will damage the contract once it's been created, and that includes not being in the correct form, okay? So you don't even get there. All right, I wasn't going to talk to you much more about the theory part because unlike some of the weeks where it's been voluminous, we've only had, I think, about 10 cases this week. I think 2 weeks ago we had 25 or 26. We only had 10 cases tonight.
Yeah, that's an offer acceptance.
Yeah, I thought it just before Christmas, so we'll lay off the cases a bit, you know. And I was looking for my Christmas hat tonight, and I couldn't find it. I thought the kids had run off with it somewhere, you know. All right, let's go to the tutorial question. Now, could someone give me the facts? One of you give me the facts, and one of you give me the first, the answer, what you think is the first part. The first part is whether there is uncertainty. So give me the facts. One of you?
Well, basically, she was trying to, in a nutshell, she was putting a gear in with the removalist. They were going to look after it. At some stage in the future, when she found a place that she enjoyed, they were going to negotiate a price to get a gear sent up.
Yeah.
And that there was, and she also paid $500 insurance, I think, from memory.
Yeah. Okay. So just looking at the details, they collected her belongings. They agreed upon a price for that. They agreed to store it for a separate price for that, and she had to pay as per month price, and she had to pay for 3 months in advance. And as you said, they've agreed to the insurance, and she paid the $500, and they've and correctly they've noted that on the contract. But what the issue is now is, and understandably, they can't give a price because it's you don't know where. Now, what she could have done is said, look, can you give me a range of prices up the Queensland coast, or on a per kilometre basis, or that they'll get 3 quotes and they'll take the middle quote, something like that. But I just think it's a little bit dangerous to leave it vague. That's all. However, we do have a reasonable feel here because they said something to the effect that the nearer to Brisbane you get, the cheaper it's going to become. Because I think the removalist was in Brisbane. So the question now is this contract binding? That's the question. Okay. Someone else? What do you reckon? Let's start with uncertainty. Because we were actually specifically asked about uncertainty. So what is uncertainty, first of all?
Well, uncertainty is, do they know what the final part? Well, because this contract, as we said, is in 4 pieces. So do we know that the 4th part, which is delivering the goods to town X, what's the price for it? And we don't know. So.
Okay. So what is the definition of uncertainty?
Not not be certain.
Oh, good boy. Here's a virtual chocolate for you. Though. It's basically where the court can't attach any sensible meaning to the contract.
Yeah.
You know these things anyway. But what I want to do is by you know me, constant repetition that it begins to sink in. Here, do you think there is uncertainty? Yes or no?
Yes.
Yeah.
What about the other one, completeness?
Well, it's not complete
No.
because it has the vague term at the end there that they'll work everything out in the long run. But I also term that insurance is fairly vague as well, because it said on there on here, it's like she's paid $500, and then it says on there with the goods to be insured, which tells me that it may not quite have been insured. I might be thinking too hard about it, but
yeah, a lot of those
say how much or what has been insured or who's insured.
A lot of places have like set insurance companies, and they just go bang and do everything.
Yeah, but Daryl, it's good to think these things through, especially prior to signature. I don't have to tell you that if you don't get it into a contract prior to signature, you're not going to get it afterwards. So I commend you for doing those. Look, let's have a look again, the definition of uncertainty. This is where the court can't attach any sensible meaning to the contract, and compare that to completeness or lack of completeness. Can we understand the obligation of the parties? Now, I would submit to you, and I had a chat to Anthony Amaranth about this, and both he and I agree it is a certain contract because it's not vague. The contract, we know what's happening. Yeah. The only thing is that it's incomplete in relation to one matter, and the one matter is the price for delivery. Okay, collection has been done. Collection has been agreed upon and done. The storage has been agreed upon and 3 months in advance, all been paid, and insurance has been paid. Therefore, we've gone along the path of doing it, and we've only got one little part which is incomplete. Yeah. And we just go through the law again. No contract can ever be incomplete. It can be fully complete. Therefore, the courts understand this, but they will make two exceptions if there's an agreement to agree and there's a discretionary obligation. I don't think there's a discretionary obligation. And when I was thinking about it, I don't think there is an agreement to agree because there was if that was the case, the contract would collapse because that's the rule. It's a situation where the price has to come in. Having a look here, the contract would be enforceable for a number of reasons. We can use the reasonableness argument. We can also use we have started to execute argument. And there's a part which we haven't discussed yet. It's called quantum meruit. QUANTUMMERUIT, where it happens a lot in the construction industry or where people are giving services where for some reason you haven't agreed upon a price and would be unjust enrichment. So Michael has asked me to do some work on his boat and we just didn't get around to agree upon a price. He can't not pay me. I have to get something. And if the whole thing hits the fan, I ask for a quantum meruit, which is a reasonable amount of money for my work. And there is an implied promise there. Basically, you're going to pay me something. So I would suggest to you that there is a contract there because there is no issue in relation to uncertainty. I think it's certain. It's quite clear what the people wanted to do. However, yes, there is incomplete, and it'd be very hard for her to get out of it. But that's what Anthony and I thought about that. Comments on that?
Well, I've said what you'd said before. The company could have attached a list of costings per town because they're a standard set of costings.
Yeah.
But then in the conclusion, I've said, well, the final element is not enforceable as the delivery clause, and the delivery clause can easily be severed from the contract because the rest of the work has been done and paid for. So you could remove the delivery.
Yeah, you could do that. You could ask the court to sever that.
Yeah.
Yeah, you could ask for severance there, but that may make it a little bit more difficult. The court might just say, look, find out a reasonable price and get the delivery people to do that. But at least you're thinking well here. Just while we're there, what about the third question about formalities? The actual question we were asked was, finally, is this a contract subject to any formal requirements? And if so, have they been met? So any formal requirements?
Well, she is renting a storage space. So that is property, and then that comes under the fact that it has to be written.
That's in writing, yeah.
Because she is leasing property.
A good point. I want to commend you for legally thinking that through. It's more that's statute of frauds relates to the purchase and rental, but more of it's like you have your home, I have your office there. This is what she's doing. She's renting it like she's putting her stuff in a corner somewhere in the place. But it's also like a hotel room. You don't need to do a hotel room in writing.
Yeah.
But again, it shows good legal reasoning. Here, you don't need to have. It doesn't need to be in writing. But listen, you have it in writing anyway. The purpose why Anthony put that in is to get people thinking about which contracts should be in writing, which shouldn't be in writing. Now, as we know, you should always put contracts in, not always, but the more serious ones, like this one, should be in writing. But it does not need to be in writing. It could be verbal. And that's one, Michael, what you're talking about is for commercial real estate and for residential, but not for renting space, like dump your gear somewhere. So any other questions for tonight?
So basically, the courts would tell them to keep going with the contract on this one.
Yeah. She should have a pretty hard time getting out of it, Now, you've got two questions. You've got the tender question and you've got the golfing question. Just look at the offer and acceptance parts to them and just follow them through step by step. Okay? And just list the steps. Bang, 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 bang. Because that's the way to do it. And you use your rules in both of them. Okay? And does anyone play golf? Either of you play golf?
Yeah, I enjoy golf.
Well, therefore, next time you talk to your buddies, you tell them that at uni you're doing this this question for your take-home exam or your assessment, your 40% assessment on the golfer, and ask what they would do.
They'd be off with a bloody car if they got a hole in one or not.
But just remember, he was the only one who got a hole in one, and they watched him. So problems of proof don't exist. That there were witnesses who actually saw the hole in one occur, both of his own team and others nearby. Now, other situations you might have it such that no one saw it, and then he wouldn't have proof. But remember, from your introduction to law subject, he or she who alleges must prove their case. So this guy must prove their case and must have evidence that they've actually got the hole in one. And if you can't do that, well, you give up. And I remember I had a guy in one of my corporate training. He said to me after the class, he said to me, he bought this BMW. I think he paid about 10 grand for it, and they didn't even do a written contract. They just did a handshake, and he paid him the 10 grand. And a couple of days later, the thing broke down, and he needed a very substantial amount of money. I think about 6 grand worth of repairs. And he said to me that, what can you do? And I said to him, well, what did the guy say to me? He said, I was in good condition. I said, do you have a check? He said, no. Did you put it in writing? No. Did you put this clause? No. Any witnesses? No. And I thought to myself, you should really protect your interests. Yeah. See, this guy would have to go to court and prove that his version of the facts was more correct than the vendor's version of the facts, and he wouldn't be able to do that. So I just said to him, look, it's very difficult. Okay, so I hope that Santa is going to be very generous to you. This time I will hope to remember to press record. I pressed record before to press stop, because last time I was a bit flustered. We had again problems getting on, and then I had to re-record it straight afterwards. But anyway, just a reminder. 5th of January, get it in, make sure it's the correct time. It's Australian Eastern Standard Time, which is Queensland time. Make sure it's 11:45 p.m. My strong suggestion, very strong suggestion, is never ever leave everything to the last day. Do it 1 or 2 days beforehand, because if there's a home emergency, something like that, you're not going to miss out. You don't have to do all the paperwork of trying to get an extension or something like that. So have a go at that. And next time we'll meet in a fortnight, there'll be that practical session. Okay, and the practical session really is just an extension of what you've just been doing here. Is getting all going. Right? And again, I remind you, critically read the newspapers, listen to TV, watch TV, listen to the radio and stuff like that, and ask yourself, why are people doing these things? When you see a contract in front of you, small, large, whatever, ask, what is this clause? What's the purpose of this clause? Is there a contract? Who are the parties involved? And that's the way to learn these things, okay? That's good. So Merry Christmas to you all, and we'll see you again in a fortnight. Any major issues, give me an email, okay?
Right. Merry Christmas.
See you later. All the best to you. Okay. Bye-bye.